Our next panel this session is titled Ethics in International Arbitration, a Legal Quagmire. The panelists for this session are Professor Benjamin Hughes, member of the SIAC Court of Arbitration, Ms. Sheila Ahuja, partner at Allen & Overy, Mr. Chua Ki Loon, partner at Allen & Gledhill, and Ms. Ko Sui Yen, SC, partner at Wong Partnership. Joining us virtually is Professor Catherine Rogers, law professor at Bocconi University, and founder and CEO of Arbitrator Intelligence. The session will be moderated by Ms. Funke Adekoya, SAN, member of the SIAC Court of Arbitration. Adekoya, please.
Hello, everyone. Why are we discussing ethics, and why is it a legal quagmire? As we had heard when the discussions were ongoing with the minister, the essence of international arbitration is that it brings together parties and counsel from different backgrounds. And because they have different backgrounds, they have different cultural issues, and they also possibly may have different legal systems. We bring this all into a set of proceedings and find out that the parties and their legal representatives may have different views in terms of how to respond to the issues that arise in the course of an arbitration. The aspects of this legal quagmire that we'll be discussing, or the reasons for the quagmire already stated in the program. I'm very aware of the fact that this is the panel that is before lunch. And the last thing that we'd like to do is to keep you from your lunch. And so I'm not going to formally introduce the panelists. Their details are in the program and their names have already been announced. What I am going to do is to state that the panel will handle this topic by way of having each panelist speak to a particular aspect of the legal quagmire. I'm going to start with Professor Catherine Rogers, and I'm going to ask her to speak to the legal quagmire with a general overview, and also to concentrate on the issues that can arise from disclosure and conflict requirements. So Catherine, over to you.
Great. Well, thank you for the introduction and for having me also virtually. I certainly regret that I could not be there in person, but virtually is definitely a good second best. So I am going to do, I believe, a sort of general overview that'll hopefully set the stage for the comments to come. And I'll make three major points. The first one is I'd like to sort of set the stage of what the environment is. And I often characterize ethics in international arbitration as effectively a no man's land. Most people think a no man's land is a vacant space, but in fact, it has a very technical meaning. A no man's land is actually the disputed territory between two parties that are at war. As a result of the fact that it's disputed territory, it's uncertain what rules apply. And this is, in fact, the very situation with international arbitration and ethics. The number of rules that may apply are very complex, coming from the parties, the attorneys, the arbitrators. What makes this even more, this complex intersection of various potential sources, is that the sources, as alluded to by Funke in the introduction, are very culturally determined. So what's ethical in one culture may actually be considered prohibited in another. These kinds of collisions come up with regard to confidentiality and disclosure, with regard to differences about what constitutes a conflict of interest, both for arbitrators and for counsel. In addition to the complexities that come with culturally defined ethics, we also see that when they collide, the parties may not just be accountable to an arbitral tribunal and their counsel and the arbitrators might just be accountable to an arbitral institution. But in fact, they might have consequences at home with discipline from their home bar associations or malpractice claims, for example, from their clients. So it's a very complex a complex field with not a lot of clear answers, even if there have been efforts, for example, with the IBA guidelines on party representation and some other important initiatives. But now, if this is complex enough, my second point is, to quote Bob Dylan, the times they are changing. I think we are seeing, and we won't fully appreciate until some years after the pandemic, a tectonic shift in the demographics of international arbitration practice. Put most simply, the practice is broadening and flattening, and that is a very good thing for diversity. What I mean by that is that we are seeing practitioners and arbitrators from cultures, legal systems around the world that never had a seat at the table coming up and having an important role to play. But what those changes mean is new sources of ethics. We have new ideas about what is ethical and what is not. These ideas also, even if ethics rules are written down in most legal systems, oftentimes the assumptions that give rise to or that define the parameters of a particular rule are not clear or clearly defined. So these new players bring new expectations and also new ways that these competing systems might interact. They also bring, I believe, new expectations. One of the tricky parts about ethics in international arbitration is that so much of what conducted ends up being an implicit assumption or expectation rather than an explicit understanding. That's why new rules or guidelines like those of the IBA, the Spanish Arbitration Club has implemented some. I know there's been work also in Singapore, making these different expectations explicit is itself part of the process of helping provide guidance for sometimes situations where there are no clear rules and cannot be clear rules. In addition, and I think this is one really important development in the new changes that are come demographically, is we're seeing much more dramatic, and I think we will see in the future, much more intensive competition. Now, what I study as an academic is the relationship between professional conduct and professional conduct rules and marketplaces. Because of course, even though we oftentimes regard them as separate, ethics are what you do when you sit on your yoga mat and meditate about what the right thing to do is, hermetically sealed off from the rest of the world, that's not what ethics are. Ethics are making decisions about what is the right thing to do, and right in quotation marks, because again, it's not always clearly defined by any particular set of rules or guidelines. But it's determining what you need to do professionally and ethically in light of pressure from your client, pressure from your law firm, pressure to get new business as an arbitrator, new appointments, pressure from your family in terms of earning more to support them. So ethical decisions occur not only in a complex milieu in the arbitration proceedings, but also in a very complex set of considerations in your own life as a professional. And that brings me to my last point. I think I'll finish, hopefully even a little early. International arbitration is an incredibly unique practice area, precisely because, unlike any other area that I'm truly aware of, practitioners are in fact the custodians of the system. It is the practitioners who actually work through, who iron out, who plow through these very difficult, complex situations where there are no clear answers. It's arbitrators who make rulings. It's counsel and parties who come to agreements on particular issues. It's the courts that end up ruling on what the final outcome is. What that means, however, is that when we are custodians of the system, is that for the system to continue to survive and thrive, it's important, and this is the one takeaway I would like to give you, that we all act primarily not only in our short-term personal self-interest, but we try as much as possible to work on making ethical decisions with an eye toward a collective, long-term self-interest. What does that mean? Your client is pressing you to make what you understand under any legal regime to be a completely frivolous argument. A lot of pressure from the client, a lot of pressure from your firm to keep the client happy. But continuous knocking down of standard rules with frivolous challenges can have an effect on the system. Continuous challenges to arbitrators that are frivolous, something I'm working on right now. It's estimated, at least the statistics that are available from institutions I know, that 80 to 90% of all challenges to arbitrators are rejected. Okay, that means one of three things. Challenges are made in good faith and no one understands what the rules are. Challenges are made in bad faith and frivolous, or there are challenges that are being made because the people making them are unhappy with the current rules and are looking for change. So with that, I will leave you with that one admonition. The one thing we can all do through all this confusion is work to make decisions that are in not only our most obvious personal and professional short-term interests, but in the collective long-term interests of the system that we are all charged with the study of that. So with that, let me turn it back to Funke and the panel there in person.
Thank you very much, Catherine. We missed having you here in person, but it's lovely listening to you virtually. She has described international arbitration as a no man's land area because people are coming from diverse backgrounds. And she says that the result of this diversity has been new ways of doing things and new expectations. She says the times are changing and we also need to change with those times. One of the areas in which the times are changing is an area where we have counsel acting as experts and also acting as counsel. We have issues of counsel also acting as arbitrators. In the recent amendment to the ICSID rules, the question of double hatting came up for discussion. Even at the Arbitral Working Group, the issue of double hatting is also a current topic of discussion. And so in terms of ethics and the legal quagmire, and the issue for us all to not just take note of our personal interests, but the long-term interests of the arbitration community, I'm going to ask Sheila Ahuja to speak to the issue of double hatting and the issues that can arise. Thanks.
Thank you. Thanks, Funke, and it's great to be here. So I'm going to use 10 minutes to talk about double hatting, and I'm reminded by this Mission Impossible type timer sitting in front of me of when I'm up, so I'll try not to overrun. I thought I might study the topic, and I looked at first what the actual topic assigned to us meant. So I went onto Google and I typed Quagmire, just, to give myself some ideas. And I got a soft, boggy area of land that gives way underfoot. So it didn't give me much. And then I typed the word legal in front of it, which started to make sense. And a legal quagmire is an awkward, complex, or hazardous situation. A synonym to that was mess. So I thought that was a very interesting start. One of the more, I guess, professional iterations of this mess is this concept of double hatting. What does double hatting mean? It's essentially two roles, as Funke described it. Most commonly, what we see is where an individual is playing the role of counsel and arbitrator. Of course, there are situations where you could play one of those roles and then also be an expert or a mediator, which is also very common. But we talk about this as an issue that we need to discuss. In fact, when one thinks about what double hatting is, sometimes it's just a consequence of our professional development. For those of us who start in common law type worlds, you don't think of yourself as somebody who can be in a judicial position, which you take as analogous to an arbitrator role from day one. You think first I have to be counsel, I have to learn that role. And then you do a career as counsel, and somewhere along the line, you start to take arbitral appointments. and then you enter into this world of double hatting, maybe for a short period, and then you exit that world and you become an arbitrator potentially. Of course, some people do it the other way, depends on the system that you grew up in. And some people have professional careers as arbitrators from the beginning or from a lateral field. But what you find is some senior arbitrators still take on work as counsel, maybe just for the larger cases. So double hatting exists most commonly in this type of counsel arbitrator situation. There are, of course, situations, and I can think of, where we require expert evidence from lawyers, for instance, where you have senior counsel also doubling up as experts in arbitration matters or even court proceedings. So the starting point or premise is there's nothing wrong with this. As a matter of principle, it's just the way things work, actually. What are then the issues that arise? The most obvious issue that arises is a conflict as between parties. So this is not new, of course, and most often if you work for a law firm, for instance, which I do, you'll find that your conflicts process, much as that probably won't bring a smile to anyone's face with thinking about having to go through it from a law firm, filters out these issues where if you are acting as counsel for a particular client, can you also be arbitrator for the same client? I mean, before anyone else can raise issues, the IBA guidelines or whatever, it's our own conflicts team that will be at my door saying, are you kidding? And likewise, where you have a situation where one party has appointed an arbitrator, and so say I'm counsel and I appoint an arbitrator, where we have a parallel case and the roles are reversed. So I am counsel and that person is arbitrator. I can't remember which way around I did that now, but where we cross roles essentially. And of course, again, in theory, there's nothing wrong with it, but then there starts to become a concept of back scratching mutually. And this is where the problems sort of start to arise. And although I don't want to be citing cases, I mentioned that this problem was sort of identified a long time ago. I mean, in the investment treaty space, we had as far back as 2002, the SGS and Pakistan case, where we had a claimant who challenged the arbitrator appointed by the respondent, because in another case, that respondent was the presiding arbitrator and decided in favor of who was claimant in this case. So it was a situation, who's arbitrator in this case. So it was a situation where there was a positive precedent and they sort of crossed roles in that sense. Likewise, in a more recent decision, in 2020, there's an ICSID tribunal in a case called ISER Infrastructure in Spain, where there was an award annulled, actually, $128 million euro-dollar award on account of the claimant appointed arbitrator failing to disclose a professional relationship with the claimant's damages expert, which led to the tribunal being improperly constituted. So you do see situations like that still, where there are relationships, notwithstanding the IBA guidelines and some rules as a premise, where the relationship is scrutinized and sometimes comes out on the wrong side in a decision. The more, I think, difficult question is that which arises on issue conflict. So a situation where you have what's said is that there might be an actual or perceived bias in the adjudicator's mind, given that they may have argued or written about issues related to or very similar to what are at stake. And of course, again, we've seen this quite heavily in the investment treaty context. But actually, even in the situation of commercial arbitration, this can arise. And I'll come on to deal with this. Is this a problem only in investment treaties? And I would argue not. So where you had a situation of, I guess the most obvious example, actually, the late Professor Emmanuel Gaillard, who appeared in Telecom Malaysia and Ghana in 2003, subsequently appointed at the same time or in an overlapping situation as claimant appointed arbitrator in that case. And he was acting in another case as claimant's counsel in an ICSID annulment proceeding in RFCC in Morocco. And the Hague District Court found in 2004 that because both cases involved similar legal issues, that Professor Gayat had to choose which role he wanted to play. So again, there was an inquiry into the substantive issues here and whether there was an overlap, and a decision was made accordingly then that both roles could not exist. So the question therefore arises is that can you actually play both roles? To what extent does double hatting need regulation? And a precursor question is that regulation only important in the investment treaty context? And Funke mentioned the amendment to this code, the UNCITRAL ICSID proposal on moderating double hatting or regulating double hatting. But I would argue as a precursor step that actually it is relevant in commercial arbitration as well, not just in investment treaty. Of course, we see it more in an investment treaty because, first of all, there's more transparency. So arbitral appointments are known right from the beginning. And more importantly, issue conflict becomes a clear issue to raise and identify, particularly at the start, because first of all, where you have common treaty provisions and somebody has argued publicly in favor of one set of treaty provisions or decided them in a certain way, this forms the most common premise in the investment treaty context of issue conflict disputes or challenges. But actually, the same thing could arise in commercial arbitration, particularly as transparency is growing in commercial arbitration. So I'll give you an example. I first started my career out of Hong Kong and started doing what became a domino effect following the GFC in 2007-8 of derivatives disputes. And at that time, no one had heard of, well, we'd heard of the products. And if you did a capital market seat like I did, you'd come out thinking, that's something I'm never going to know about. And then you do a dispute on them and think, wow, that's really interesting. So I started doing that and thought, I'm going to become a specialist in this, really fascinating stuff. And everyone was fighting these products at the time. But what started to happen is in the West, so in places like England and Europe, they had court clauses, whilst in Asia, we saw arbitration clauses. So that also coincided with actually the very significant development of financial arbitration disputes in this part of the world. But what was happening is all these disputes were being decided privately. So what constituted a hedge versus speculation, whether the FEMA guidelines in India, if they were breached, rendered the product invalid, or was it just a regulatory fine? All those issues were being decided by private arbitral tribunals. And then they were also appearing as counsel in other decisions where they said, well, I've argued this or I've decided this 6 times over. Here are the redacted awards. And so the jurisprudence was being built essentially privately by a handful of people. Just to be clear, I did not act as arbitrator in any one of those cases at the time. But what that served is an example of something where you did have a situation that possibly could have benefited from some regulation, where even in the context of commercial arbitration, you had very, very similar, if not identical issues arising from the same set of guidelines or same type of products, and nothing could be done at the time to address that. Now, what's the answer to that? It's similar to, Catherine's topic, and I'm going to cite Catherine in a moment, in fact, is that in the investment treaty context, there is some proposed regulation. So there are these codes, there's this draft code of conduct, which essentially has a 3-year guideline for simultaneously also, you can't take appointments where there's a legal issue or the same parties or similar situation in another dispute. Whether or not that will go, and I can sit and read out the provision, but that may not be the best use of time. But whether that will be sufficient to resolve the situations rather depends on, can you identify the legal issues early on enough? And perhaps in treaty situations, you actually can, because they do tend to become clear at the start what you're basing your claim on. But where it concerns commercial arbitration, how is that translatable? We already have the IBA guidelines and the orange list situation where it concerns parties. So one does have to ask oneself, do I have to make a disclosure as arbitrator? Interestingly, not as counsel. And there is a question that we ask ourselves, I act predominantly as counsel. If I'm in that situation, do I have the obligation and should I exercise that obligation to say, maybe that arbitrator, even if appointed by the other side, which could be ideal, shouldn't be because there are similar issues arising elsewhere where I'm appearing as counsel. I think the answer to that must be that there should be some more self-regulation because to have this uniform code that applies across commercial arbitration is tricky, although there have been efforts, obviously, to do that. But I wanted to cite Catherine's book on ethics in international arbitration, where she says, self-regulation of the professional conduct of participants in international arbitration is not a question that is open for debate. It is inevitable. The question is only how well it will be managed. And I think that is the answer. One has to ask oneself in that situation, over and above the guidelines, over and above what your conflicts department will tell you, even though at the end of that process, you're really done with the topic of ethics, I would say, am I in that situation where something just feels like it might become a mess? In which case, take the further step and try to think about how to regulate it.
Thank you very much, Sheila. What I hear from your presentation is that the legal quagmire is actually land that gives way underfoot. And if you take the land to be the guidelines that you've referred to, the IBA guidelines and other guidelines, you come up with the conclusion that self-regulation is possibly the answer to some of the ethical issues that parties and counsel will meet within the context of international arbitration. I'm going to disclose my prejudices by now asking Ko Sui Yen to speak on the ethical regulation of parties and counsel, whether the guidelines that we have are sufficient, the role of arbitral institutions in providing the guidelines, what can the tribunal do if they are breached, the extent to which self-regulation that Sheila has posed may be the solution.
Thank you very much, Funke. Good afternoon, everyone. I think one of the first thing we must bear in mind is that we are talking about international arbitration. When we talk about international arbitration, I don't think it's enough to just say, we'll leave it to the National Bar. We'll leave it to the National Bar Council. We can't, because that in itself is unequal. Which then brings me to the next question. So whose responsibility is it to maintain integrity and fairness of the arbitral proceedings? I think everyone would say arbitrators, they play a very important role. Arbitral institutions, they play a very important role. Party representatives, counsel, do they not likewise play a very important role? They do. What is integral to the maintenance of integrity and fairness in arbitral proceedings to me is the equal conduct of international arbitration. And if we believe in the equal conduct of international arbitration, regulation is critical. Why do I say that? Let me just give two examples. Witness preparation. Across all jurisdictions in the world, everyone has a different perception as to what witness preparation can entail or should it be done. You heard of the sort of what they say the more conservative approach in the UK. Absolutely no witness preparation or rehearsal. You heard about the more liberal approach in the US, where it may even be an obligation to ensure that your witness knows how to answer the questions, and you can even assist your witness to, in a sense, frame his or her answers. You have the middle house like Singapore. You can have witness preparation, ensure that it's the witness testimony, do not supplant the witness testimony, do not prepare in groups. Divergent approaches. And why does it matter for there to be actually some common consensus? Because once you have a divergent approach in witness preparation, that will not result in equal conduct in international arbitration. That is a problem. Document production. Again, we do a very general statement, civil law, common law, different approaches. Common law of discovery, everyone is familiar with that. Civil law, perhaps you only produce the documents you wish to rely on. That creates that inequality again. Why? When the counsel is acting for a party and faced with an order for production of documents, does the counsel simply forward it to the client and say, please, this is the order, comply? Does the counsel take a further step to look at the documents that the client gives and inquire and say, there's some gaps here. This may fall within the discovery order. Please look further. Does the counsel take an even further step to say, give me your email outlook. I will go through this and I will help you look for the documents that fall within this order. Again, you have two opposing counsels if they adopt different approaches. How is that an equal playing field? And which is why, and Funke, you disclose your sort of conflict of interest at the start. I wanted to say, I really applaud the IBA guidelines of party representation. You are a member of that task force, very difficult guidelines to come to. I think it was passed in 2014. 2013 was the conflicts of interest. You have the IBA rules on taking evidence, 2010, revised in 2020. But what happened after the IBA passed those guidelines was that we then had many seminars talking about ethics. Many participants in these seminars and arbitration practitioners who say, and most of them, they object. They object to the adoption of the IBA guidelines. They object to the idea of ethical regulation. They object to the idea of, to me, sort of equalizing how each party representative conduct the arbitration. And it may be because at that point in time, 2013, 2014, the guidelines were coming out with full force. Everyone was talking about it at every seminar. I'm so glad SIAC brought this back today. They brought it back today. We are 6-7 years since the guidelines came about. And then I want to say, 6-7 years down the road, are we still saying we have not reached an international consensus? And it is very interesting because I went to look around the arbitral institution's rules. And I was very, and I've done an LCIA arbitration, sitting as an arbitrator. And within the LCIA rules, which were, 2014, there is actually specific provisions that mandate every counsel who wishes to participate in an LCIA arbitration to comply with the general guidelines for parties' legal representations. It is made as an annex to the LCIA rules. Article 18.5 of the LCIA rules says, in order to represent someone as counsel in an international arbitration under the LCIA rules, your counsel must undertake to comply with these guidelines. 7 paragraphs guidelines, very interesting. Let me just cite 3. Paragraph 3. A legal representative should not knowingly make any false statement to the arbitral tribunal or the LCIA court. 4. A legal representative should not knowingly procure or assist in the preparation of or rely upon any false evidence presented to the tribunal or the LCIA court. 5. A legal representative should not knowingly conceal or assist in the concealment of any document or any part thereof which is ordered to be produced by the tribunal. Everyone, as you sit here, are these 3 paragraphs that I read out that out of this world, that difficult, that challenging, that everyone sitting here would not nod and say, well, that must be right. There must be an international consensus of at least that very minimum, not to make a false representation of fact knowingly. Knowingly is the key. So when I look at that and I see, there seems to be a general agreement at a high level that there are certain things which we should not do. So why is there still this, we have not moved forward? We have not moved forward in the conversations when the guidelines were passed in 2013. Put forward by the council for parties' consideration in 2013 to where we are today. And I say, it needs us to do more. Who? I started by saying arbitrators. Arbitrators because we see the draft procedural order. We always see IBA rules on taking up evidence. The survey shows that it's probably adopted in 70% of international arbitration. IBA rules on party representatives. Many people do not even know about it. The adoption rate back in 2015 was like 24% based on the Queen Mary survey. I haven't been able to find the latest survey. But perhaps we should just go back and revisit the IBA guidelines on party representatives. When we sit as arbitrators, to look at that and to see, do we think this is appropriate to ask parties to consider in the arbitration and to adopt in the arbitration? Likewise, the conflict of interest. I mean, I myself have my slight reservations on certain of those guidelines. So I'm not, saying, but again, tribunals should take a look at that and see, is the IBA guidelines on conflict of interest one that's worth adopting? When you put it forward and you make a concerted attempt and you put it in draft procedural order number 1, I think it'll be very difficult to find two sets of opposing counsel who will then say to the tribunal, both of us do not wish to adopt these guidelines. And if that's what they wish to do, so be it. But at least you as a tribunal are aware, perhaps what are the party representatives that you have to be prepared for and to deal with. Institutions. Well, we see what LCIA has done in 2014. I think very forward-looking. I think they made it a condition of representation. Very brave move. In fact, one would be surprised how LCIA was so brave. Would they not be concerned that suddenly people would take LCIA out of the arbitration clause and say, no, we will not have LCIA arbitration because there's a condition for my lawyer to comply with? Surprisingly, no. When there was a survey done on the adoption of LCIA arbitration rules, everyone applauded the move. They said, well, very good, because we want that equal playing field when we have counsel and participants from all over the world. So I guess that's where I'm pushing for change. And I want to hear questions about this because I think it's a conversation worth having today.
Thank you very much, Swee Yen. Obviously, her position is that self-regulation is actually encoded into the various guidelines that have been instituted. The IBA seems to have covered the field, conflicts of interest, ethics, taking evidence, and that it's left to the tribunals perhaps to implement this by way of procedural orders. Now, if that is her view, there's one aspect of this legal quagmire that possibly has not yet been covered by arbitral rules and arbitral guidelines, and that's the issue of third-party funding, and perhaps the issue of disclosure. How far should we go in that respect? And for that, I'm going to ask Chua Ki-Loon to speak on the issue of regulation of third-party funding as an ethical issue and whether it does fit a question.
Thank you, Fung Ting. I think today we are seeing an increased use and demand for third-party funders to fund international arbitrations. In fact, over the last few years, we have seen jurisdictions such as Hong Kong and Singapore introduce legislations to permit third-party funding. The emergence of third-party funding naturally introduces a number of issues for the international arbitration community, including two such topics that I will touch on today. First, relates to the conflict of interest that may arise from the relationship between the third-party funder and the arbitrator. And related second topic, which is to what extent should such third-party funding arrangement be compelled to be disclosed in the arbitration? I think on the first issue of potential conflict of interest, we all know that it is an essential cornerstone of arbitration that an arbitrator must be impartial and independent of the parties. With third-party funding and arbitration and thereby acquiring an interest in the outcome of the arbitration, the obvious and natural consequence is that now exists a potential conflict of interest issue arising from the relationship between the arbitrator and the third-party funder. The At the extreme end of the spectrum, the most obvious illustration of this conflict is where the arbitrator has a direct interest in the funder, and the arbitrator's decision in the arbitration will therefore have a direct impact on his own interests. This scenario is fairly straightforward because it clearly goes to the impartiality and independence of the arbitrator, and the award will naturally be open to be set aside on that basis. But the potential relationship between a funder and the arbitrator can span across a wide spectrum. For example, an arbitrator may be a lawyer who has previously worked with the funder on a number of unrelated cases. Or even closer, the arbitrator may be a lawyer who has previously received a number of referrals from the third-party funder. And even more remotely, perhaps one step more remote, is that the arbitrator belongs to a firm where his partners have such a relationship with the funder. Invariably, regardless of the nature of the relationship between the funder and the arbitrator, the possibility of the arbitrator's impartiality and independence being challenged may arise. The question then is, how should an arbitrator faced with such scenario deal with his or her appointment? And I think this is where self-regulation comes in, where guidance can be found in the IBA guidelines on conflict of interest. If one were to look at the general standard number 6, there is an express provision that says, if one of the parties is a legal entity and any legal or physical person having controlling influence on the legal entity or direct economic interest in or duty to indemnify a party, the award to be rendered in the arbitration may be considered to bear the identity of the parties. Now, even though third-party funders are not expressly spelled out in the general standards, the explanation to General Standard 6 expressly provides that third-party funders and insurers in relation to dispute may have a direct economic interest in the award and as such may be considered as equivalent to the party. Therefore, for the purposes of determining potential conflict of interest, an arbitrator should consider a third-party funder as equivalent to the party and applying the general standards to guide him in assessment, including reference to Part 2 of the IBA guidelines on conflict of interest, which is where the list, the well-known red, orange, and green lists, which sets out non-exhaustive specific situations that are likely to occur in arbitration today and how the arbitrators should react accordingly. It is clear from this illustration that the IBA guidelines that in most situations, the IBA guidelines should provide sufficient guidance to arbitrators faced with potential conflict of issues that arise out of these third-party funding arrangements. Ultimately, what is critical is whether the arbitrator needs to determine is whether the nature of the relationship raises justifiable doubts as to the independence and impartiality of the arbitrator. This then goes on to the second topic that I will talk about, which is to what extent should this third-party funding arrangement be disclosed in the arbitration. As illustrated earlier, the existence of third-party funders give rise to potential conflict of interest issues relating to the arbitrator's appointment. As such, there is a need for there to be obligation to disclose at the very minimum the existence and identity of the third-party funder. This is crucial to preserve the integrity of the arbitrator's appointment and, more importantly, the award that is to be issued by the arbitrator. In fact, even though this rule does not appear uniformly in all institutional rules, we are beginning to see some of these such rules appearing in rules such as the ICC Rule 11.7, where it compels party to disclose the existence and identity of third-party funders, And over here in Singapore, the legal professional conduct rules at section 49A provides that a legal practitioner must disclose the existence and the identity and address of the third-party funder. In relation to the professional conduct rules in Singapore, this naturally only applies to practitioners who are subject to these conduct rules. And in a sense, at the moment, it creates an unequal footing. I think that's something that Siac was touched upon earlier, whereby the Singapore lawyers are bound by these rules to disclose the funding, but not necessary. But this obligation does not extend to representatives and lawyers who are not subject to the professional conduct rules. Now, another example is the SIAC investment arbitration rules, which went further than the ICC rules. Not only does the SIAC investment rules empower an arbitrator to order disclosure of the existence and identity of the funder, the Rule 24 of the SIAC investment rules went further to say that where appropriate, details of the third party's funder's interest in the outcome of the proceedings and whether or not third-party funder has committed to undertake adverse cause liability, the arbitrator may be able to order such disclosure. Now, the disclosure of details of the funding arrangement beyond existence as identity is not so straightforward. On the one hand, the argument against disclosure typically revolves around the assertion that opposing parties will obtain unfair advantage by revealing strategic and commercial considerations. Questions such as, would such disclosure prejudice the party funded when the third party commercial terms reflect a substantial doubt on the funded party's part as to the merits of its own case? But on the other hand, the disclosure of such terms may be in reality relevant to the determination of the actual costs that is being incurred by the funded parties, which the opposing party may be held to be liable for. This is particularly relevant when it is still a fairly common practice in arbitration today, where arbitrators do not require evidential proof of the cost claimed by the parties to have been incurred in arbitration. My view is that ultimately each case has to be decided on the merits of the specific case, balancing the interests of the parties in that particular case. The ideal position, therefore, it must be to ensure that the disclosure of the existence and the identity of the funder is compelled, and leave the decision as to the extent of the disclosure of the arrangement in the arbitrator's hands.
Thank you. Third-party funding. You've taken the view that the IBA rules on disclosure actually cover funding, third-party funding, but that there is some sort of dichotomy between the code of professional conduct that governs Singaporean lawyers as opposed to those who are not bound by those rules, where the arbitration is taking place in Singapore. And so I think that I'm going to ask Professor Benjamin Hughes to speak to what Siac's view is in respect of professional ethics, the legal quagmire, and the issues that we've all discussed on this panel up to date. Thanks.
All right, well, thank you. Let me preface any comments I make by saying I am not authorized to speak on behalf of Siac, nor would I ever do so. But I think I'm here because I am chairing a committee of the Siac court, which has been charged with updating and revising the code of ethics and the disclosure statement for arbitrators. So that is very much a work in progress, and it is both broader in scope and more narrow in scope than what we've discussed to some extent today. It applies to arbitrators only, and so it's a little bit narrower, but it also deals with certain issues that maybe don't typically fall within our discussions of ethics, such as availability of the arbitrator to complete the award in a reasonable time period. So it's, and even with respect to the arbitrators, I think such a form, code of ethics and disclosure statement can't possibly deal with all the issues that we've raised today, and nor should it, in my view. The committee is also dealing with the tribunal secretary, which is related, as I'll discuss in a moment, to the arbitrator statement of independence, impartiality, and availability. Our first task, just to give you an idea of how long it's been since these have been updated, was to change the language of the code of ethics to be gender inclusive. It referred only to males when we found it, which was interesting to see in this day and age. So I just want to say, before I get into any of the issues we're discussing, that it's an excellent committee, and I'm now, without permission, going to name the members of the committee, because what we would like is, if any of you have ideas or comments or suggestions, that you should feel more than free and comfortable to reach out to any one of us by email or your preferred method of communication, and let us know about those so we can take them into consideration. They are Bernard Hanatel, Abi Cohen Smutny, Karina Goldberg, Shanine Parikh, and Lee Jun Kao. So it's an excellent committee. We're working very hard. Our mantra has been, I think Bernard gave us this one. We want to do everything that's necessary to update the code of ethics and the disclosure statement, make it relevant and useful, but to keep it as simple as possible. So some of the issues that have been raised so far, I think my microphone is cutting. Whether the disclosure statement should now include, along the lines of what the IC includes, a table in which the arbitrators should list all of their current arbitrator commitments or counsel commitments, et cetera, so that the institution can have some idea and the parties can have some idea of the how busy the arbitrators are, and whether there should be a table listing other time commitments. Opinions vary on that one. The ICC approach obviously has been that they want to see this information, query whether that is also disclosed to the parties. The other view is that arbitrators should be treated as professionals and simply asked to state whether they have sufficient time, because the calendars obviously change, and your cases can settle tomorrow, the day after you fill out this form. But more, I think, to the ethical considerations that we are discussing today. Again, they're focused really on independence and impartiality of the arbitrators. And, you know, as with issues like witness preparation and disclosure that Suyen mentioned, expectations can vary widely from place to place as to what should and should not be disclosed. And I've had experience in a recent case where an American arbitrator was disclosing that he had had dinner with one of the co-arbitrators about 7 years ago, You know, and so this kind of thing is it can create problems where one arbitrator is disclosing these kinds of issues and another arbitrator is not. So the thought was that we might include an additional category of disclosure for items that don't give rise to a conflict in the view of the arbitrator, but nevertheless, he or she may wish to disclose as a matter of completeness or in an abundance of caution. So we're likely to include a new category of disclosures for that. We're also going to be addressing the issue of the use of tribunal secretaries. The current Code of Ethics does reference the practice note on tribunal secretaries, but it has been a pervasive, I think, problem that sometimes arbitrators are using tribunal secretaries who have not been actually appointed and maybe have not been disclosed to the parties. And there are obvious risks associated with that. So we just want to make that more clear that the tribunal secretary or any person playing that role should be formally appointed and known to the parties. Other questions that have arisen are, should we attempt to define independence and impartiality in the Code of Ethics? That I think the general consensus is that's a potential separate quagmire that we might get ourselves into, but I'll come back to that. It's also been suggested that when disclosures are made in respect of an entity or an individual, that very specific details be provided. That's also under discussion. We do, I think, want to add a specific reference in the Code of Ethics to Rule 13.6, which is in respect of what kinds of ex parte communications are permitted with your party appointed arbitrator, because again, this is an area where expectations can differ greatly. I recall the first time a co-arbitrator called me when I was counsel to discuss what qualities we may be looking for in a chair, and I was shocked to get such a call. And now it's of course completely expected, but I've been in other arbitrations, especially, for example, in LMAA context, where this practice is regarded as absolutely alien to the culture of LMAA arbitration. So some clarity there would probably be helpful. So again, we are not attempting to reinvent the wheel, but we are trying to update the Code of Ethics and the disclosure statement and the tribunal secretary practice note to avoid some of the ambiguities that can arise. As I think, although these issues can arise from the different expectations of parties and counsel and arbitrators from different jurisdictions, and probably not often the case that they are caused by outright unethical behavior. Clarity is helpful, but at the same time, I think in some cases, less is more, and that the Code of Ethics should be general rather than specific, because once you start getting overly prescriptive, then other problems can arise, such as the idea that anything that is not prohibited is permitted. And I often see people using the IBA traffic lights in this way. I don't see it anywhere on this traffic light system under red or yellow, so we're good to go. And I think, I would hearken back to Sheila's statement earlier. This is about self-regulation at the end of the day. And you have to ask yourself, as Sheila put it, and I wrote this down because it was such a beautiful quote. Am I in a situation which feels like it might become a mess? And if so, I think we've decided as a committee that all doubts about disclosure should be resolved in favor of disclosure. So is the is the circumstance that we're talking about here, does it give rise to any reasonable or justifiable doubt as to my independence and impartiality? Then if so, it should be disclosed. Now, trying to define independence, trying to find bias or partiality is a bit thorny, but I'm reminded again of Sheila's statement and also Justice Potter Stewart, excuse me, statement about obscenity. He said, I shall not try to define it precisely, but I know it when I see it. And I think that's also the case in international commercial arbitration. We know when there is a situation which could possibly give rise to some reasonable doubt as to independence and impartiality. And in that case, it should definitely be disclosed. So I will leave it at that. I would say that, again, this is very much a work in progress. It's progressing very quickly, though. So if you have any comments that you'd like to share either today in the Q&A or with us as committee members, you can reach out to any of us by email, and we're very happy to have your input. Thank you.
Thank you, Ben. We have 15 minutes before lunch. I'm not going to keep you from lunch, but I myself do have a few questions. And I'm going to start with Catherine. Do you think that the present state of soft law regulating ethical issues is sufficient? And if you do not, what more do you think needs to be done?
That needs a whole nother panel, I think, to discuss adequately. We've had a number of examples of soft law put forward. I think to not answer your question is, I think soft law by its very nature is an ever-evolving kind of entity. It's never, the whole nature of it being soft law as opposed to hardened is a sort of recognition that it has to be flexible, it has to be constantly evolving, and also has to be adaptable to different situations, that no one single hard rule would be sufficient to address the issue. So I think we've had a number of terrific examples of evolution in soft law, from the LCIA, for example, appending its annex to evolution on third-party funding. There we have seen some soft law evolving into hard law when you see disclosure requirements put into legislation in Singapore and Hong Kong, where you see put into arbitral rules. Those become sort of hard obligations. Double hatting, we've also seen sometimes it does harden. So for example, in the commercial context, with the Court of Sports Arbitration, they actually have taken a stand because of the nature of that practice area. But interestingly enough, the ICSID UNCITRAL Code of Conduct started with a mandate by the states to essentially prohibit double hatting. But then when they got down to trying to do that, it became difficult and if not impossible. And so they've come up with much more narrowly tailored regulation. But even that code, with all the energy that's gone into it, there's a big question of whether it should be reduced to hard law and something that, analogous to the Mauritius Convention, turned into treaty obligations or incorporated into BITs. And I think there's a significant debate to be had whether that would be a healthy thing. And there's certainly, as lawyers, we're sort of drawn to hard rules, or whether it needs to continue to be flexible. I would take the latter view, in part going back to your essential question about the nature of soft law and some of my earlier remarks, that we are seeing a tremendous, not just change, but also an increasing rate of change. And I think also when you have multiple sources coming into play, it's difficult to truly understand the implications in some instances of making a soft law rule hard. So in answer to your question, I think soft law will continue to evolve. I think it's something that's also more inclusive as we have debates that happen among different entities, among different regions. In that sense, for example, the IBA guidelines on party representation, even if I think there's much to applaud in those guidelines, I was also on the task force, they've also come under significant critique, particularly from those from civil law systems saying they represent a particular cultural viewpoint. I think that's great that they're critiqued. And my sense is that there will be another iteration of them, and that iteration as a soft law instrument will be able to effectively address some of these critiques, which if they had been implemented as hard law, would be less viable. I hope that answers your question.
To an extent. Whilst we are waiting for the evolution of soft law, my question to Sheila would be double hatting. We all know that that is one way in which arbitrators grow their careers. They start out as counsel, and then they move on to arbitration as arbitrators, and they're doing both. And it's an area where conflicts can arise. Do you think that discussions on disclosure just of issue conflict would solve that problem?
I think double hatting itself shouldn't be seen as problematic in itself. You know, most of us are double hatters at some stage. I'm currently a double hatter. I wasn't always one, and I may not be one going forward at some point. So I think the starting point of the premise should be permissive. It should be that it is a phenomenon that is real and actually has a lot of benefits as well, because in the situation of, say, issues, actually having heard a matter as arbitrator, I remember when I did my first case as arbitrator, I then realized that actually when you say things as counsel, sometimes you've got to realize how you come across, and you can never really understand that until you read or listen to a party. And then you think, gosh, I've got to watch for that and hear myself more often. So actually there's a lot to be gained from that, and it's mutually beneficial. But I think that the regulation itself has to be, I think as Suyen put it, and also Ben, it has to be more general than specific. I don't actually think that issue conflict can be regulated properly. In fact, there was a statistic that I didn't mention, which actually said regulation on issue conflict is unnecessary, because what should happen is there should be enough of a challenge path such that if there are issues that render that conflict, then the challenging body would decide that, and that would be that. And actually, when you then look at the challenge statistics, which Catherine also, actually it was Funke Yu who alluded to it, there aren't that many successful challenge decisions, in fact. So that situation where there's a genuine issue conflict is actually quite rare. So my own view of that is you can sometimes over-regulate, and in circumstances where there are so many different legal systems at play here, the more generically you can deal with something, the better. And then you leave it to the individual bodies who are supervising that particular proceeding to get you to the right place. When it comes to those bodies, though, they can more closely look at whether to provide more expressly for issue conflict. Whereas at the moment, there's this kind of umbrella independence impartiality provision, and you have to work hard. It's more obvious in the situation of parties because of the IBA guidelines. It's less obvious in the situation of issue conflict, where you have to rely more on precedent. And I think that institutions maybe could think about, is it worth saying something expressly about that? Some of them do, like the Ancestral Draft Code and some institutional rules, but not all.
Thank you. Talking about regulation, I'm going to ask Suyen, because you've taken the view that it should be the tribunals that can do more in terms of personal regulation. What do you think an arbitral tribunal should do if these ethical rules are breached? Do they have jurisdiction? Should they report counsel to their relevant professional bodies? Should they sanction them? Do they have power to sanction them? What should they do?
Okay, I think before I can answer that question, it first depends on whether there are any ethical rules that govern the arbitration. Like what we stated at the start, unless you have something like the LCIA rules, which specifically make it a requirement for counsel to comply with certain guidelines before the counsel can represent the parties. And that then becomes a term of the arbitration agreement when you adopt the LCIA rules. You don't see this in any other rules. So when you don't see this in the SIC rules, the ICC rules, sitting as a tribunal, you then say, oh, are there really ethical guidelines that I can apply where I can say that it has been breached and I can then issue a sanction or reprimand? Which then brings me to the next point, that if you're not in a situation where it's a condition of the arbitration agreement, then as a tribunal, you need to, in your procedural order, decide for yourself first. Do you want to ask the parties to consider making this as part of their agreement? Whether to look at the IPA guidelines on party representation as guidance, as things which they would adopt for the purposes of that arbitration. And if they then do decide to adopt it as part of the arbitration, then under those guidelines, you would have the sanctions and you would have the power to issue written reprimand, to give caution, to draw adverse inferences. I mean, the guidelines, if you have time to look at it, sets out a whole myriad of steps that the tribunal can take, as well as the balancing of the consideration, because sometimes you don't want to penalize the counsel such that you actually are penalizing the party when the counsel is really to be blamed rather than the party, which is the client, the user of international arbitration. But putting that aside, assuming there's a scenario where you, not under the LCIA rules, there's no agreement in the procedural order to adopt any of these guidelines, and you have opposing counsel from both ends. Again, I do think a tribunal has within its powers, when we look at the general powers of ensuring that the proceedings are conducted fairly, maintaining the integrity of the arbitral proceedings, ensuring that parties are treated fairly. I mean, these are powers which and duties of the tribunal. And in order to achieve that, surely you would have the power to issue an adverse cause order. For instance, if a party refuses to comply with a discovery order that you have made. Surely, if a party constantly breaches the timeline, you as a tribunal can issue a written reprimand to say that, you know, this timeline parties should try their best to adhere to these timelines. At the end of the day, what the tribunal wishes to do really turns back to the temperament of the tribunal. So I think there are certain arbitral tribunals who may take a more heavy-handed approach. There are certain who may be more lenient. But counsel and party representatives should always bear in mind, the tribunal may not necessarily openly sanction you, issue a written reprimand, but he or she remembers. So it's not as though as you're facing a tribunal and the tribunal is silent that you then go on your ways, because I think we are all humans. Everyone remember how a party conducts itself in an international arbitration. So if you ask me, I think it takes everyone to have that same buy-in, that we want to do it fairly, honestly, and well. So, you know, that's what I hope for.
Thank you. My last question is for Kee Loon. You spoke about third-party funding. One of the issues that has come up is that the disclosure of third-party funding might prejudice the arbitrator or arbitrators, because they know that due diligence would have been performed. Third-party funding may give the impression that the claimant already has a good case, and this might actually bias the tribunal in favor of the claimant. What are your views on this? You have a minute.
I think, thank you. My view is, I don't think it is a major concern, in a sense that I don't think arbitrators, to the extent that they are professional arbitrators, would actually be prejudiced by the existence of an arbitrator or existence of a third-party funder or not, because ultimately the arbitrators would recognize that there is a whole range of reasons why a funder would fund a particular claims, and it really depends on the commercial terms that has been arrived at by the parties and the funder. So I don't really think that is a major concern. Whereas on the flip side, I think because the identity of the third-party funder goes directly to the issue of potential conflict of interest with the arbitrator, it becomes critical that any third-party funding arrangement would, at the very minimum, would have to disclose its existence and identity so that the tribunal can properly clear conflict.
Thank you very much. what we have heard is that the international arbitration scene is a legal quagmire as far as ethics are concerned. It's constantly shifting sand. There are various issues that have come up for discussion. The various arbitral institutions are looking at these issues. And as Catherine has said, things will change on a day-by-day basis, and we continue to respond to that. And as Ben has said, the Siac is itself looking at these issues and constantly updating their rules to respond to that. So all that's left for me is to thank the members of the panel for their contribution to this topic. Thank the audience for staying awake till now. And I believe you're all released for lunch. Thank you.